Good thing there's a little step for me because I'm kind of short, not like Gatto, who's very, very tall. You can't hear me? Okay. Let's see. I'll try to speak in the mic. Good afternoon to you all. I wish to thank the Holy See and the committee for inviting me to speak here today. In the little time that I have, I'm going to introduce the concept of the responsibility to protect persons against atrocities. I will argue that it should be extended to cultural heritage, and I'll discuss how the destruction thereof may result in legal and even criminal accountability. The responsibility to protect, which is also known as R2P, is a relatively new norm that seeks to ensure that the international community never again fails to halt the mass atrocity crimes of genocide, crimes against humanity, war crimes, and ethnic cleansing. The concept emerged in response to the failure of the international community to adequately respond to the mass atrocities in Rwanda and the former Yugoslavia in the 1990s. R2P was then unanimously adopted in 2005 at the UN World Summit, which was the largest gathering of heads of state and government in history. So R2P stipulates 3 pillars of responsibility. The first is that every state has the responsibility to protect its citizens, its populations from mass atrocity crimes. The second is that the wider international community has a responsibility to encourage and assist states in meeting that responsibility. And the third, if all else fails, which means if a state is manifestly failing to protect its populations, or even worse, perpetrating the atrocities, then the international community has or must be prepared to take appropriate collective action in a timely and decisive manner, always, of course, in accordance with the UN Charter. R2P remains a largely political commitment, but it is emerging as a form of soft law by repeated references to it in international discourse. It's been invoked in more than 80 UN Security Council resolutions concerning crises all over the world, as well as thematic resolutions concerning the prevention of genocide and preventing armed conflict. It's also been invoked in more than 50 Human Rights Council resolutions and 13 General Assembly resolutions. So these resolutions and their related preventative and sort of as a last resort coercive measures have demonstrated that collective action to protect populations at risk is possible. So how is this relevant to the protection of cultural heritage? An obvious constraint on extending the concept of R2P to cultural heritage is that R2P is limited for the most part to threats of mass atrocities, what's a classic mass atrocity. So can, for instance, the worst, most massive attack on heritage, can that be conceived of as an atrocity? Well, I would argue that to the extent that R2P seeks to prevent such classic atrocities as genocide and ethnic cleansing, it has to inevitably make room for seeking to also prevent cultural genocide and the erasure of cultural heritage where populations have been forcibly displaced. The original draft of Raphael Lemkin's 1948 Genocide Convention prohibited the intention to eradicate a group's culture. In Lemkin's view, the deliberate destruction of culture was a fundamental act of genocide, and which could also be a predicate to the systematic elimination of a people. So to my mind, the same pattern or thought process readily applies also to ethnic cleansing, which actually most people wrongly think necessarily involves killing. But the official UN definition of ethnic cleansing is to render an area ethnically homogeneous by using force or intimidation to remove from a given area persons of another ethnic or religious group. And the best way to ensure that a population is permanently removed from an area is to ensure that they have nothing to return to. The final version of the Genocide Convention, I think as most people know, sadly makes no mention of cultural genocide. But this was a purely political decision at the end of the deliberation process. The convention does, of course, single out 4 categories of persons, namely national, ethnic, religious, and racial, whose survival is at stake and whose protection therefore warrants special attention by the international community. And these categories all have profoundly cultural dimensions, but it's not the same as explicitly protecting them from a specific intent to destroy their culture. Nevertheless, the concept of banning cultural genocide in international law is not really rejected, it's just silently present. It's silent because it's hidden under different names. For instance, a form of genocide is the forced assimilation or forcible transfer of children, which amounts to deliberately depriving them of their cultural roots. It's also generally accepted that mass attacks on cultural heritage are often precursors or concomitants of atrocities against persons. They also readily lend themselves to constituting evidence in support of the intent to commit the crime, or mens rea, to commit primary atrocity crimes. The International Court of Justice has established, in applying the Genocide Convention, that it may take account of attacks on cultural and religious property in order to establish the intent to destroy a group physically. And this is a fundamental element of the crime. So it's also the hardest element to prove because you don't see it, you don't see intent. So while each type of threat may be insufficient in itself to constitute an atrocity per se, taken together, they may satisfy that requirement of R2P. And to this end, UNESCO has recognized that an extension of R2P to cultural heritage would strengthen safeguards thereof when it is under threat. These include enhanced military defense, cultural protected zones, and safe havens. The modern law of armed conflict also contains such safeguards. And national and international prosecutions after the commission of an attack on heritage might also be regarded as safeguards if they serve to deter such attacks in the future. In this respect, the case before the International Criminal Court of the prosecutor versus Al-Mahdi is perhaps the most instructive. It's also the most recently relevant. Ahmad al-Faqi al-Mahdi was, I probably said that wrong, was a member of a radical Islamic Malian armed jihadist group linked to al-Qaeda in the Islamic Maghreb. Al-Mahdi served as head of the Islamic police in Timbuktu and was one of the 4 commanders of the group during its brutal occupation of Timbuktu in 2012. Various hostilities took place at the time, including flagrant violations of international humanitarian law, or what we call the law of armed conflict. So the ICC indicted al-Mahdi on several charges of war crimes, specifically the intentional attack against 10 religious and historic buildings and monuments. Article 8.2E4 of the ICC statute provides that war crimes include intentionally directing attacks against buildings dedicated to religion, education, art, science, or charitable purposes, historic monuments, hospitals, and places where the sick and wounded are collected, provided that they are not military objectives. So if a church has a bunch of soldiers and ammunition in it, unfortunately, it loses its protection. The al-Mahdi case at the ICC unfolded relatively quickly and efficiently. The Malian government itself referred the situation in Mali to the court in 2012. The ICC prosecutor then opened an official investigation into alleged war crimes committed in Mali in 2013, and in September 2015, the ICC pretrial chamber issued an arrest warrant against al-Mahdi. 1 week later, he was arrested. He was transferred to The Hague by the authorities of the government of Niger. This arrest caught many by surprise. Al-Mahdi indicated that he would plead guilty on March 1st, 2016. His trial opened in August that year and concluded within a single week, which is almost unheard of in international criminal justice. The court convicted him of the war crime of intentionally attacking religious and historic monuments, sentenced him to 9 years in prison, and ordered that he must pay the amount of 2 million euros or 3.2 million US dollars in expenses for individual and collective reparations to the community of Timbuktu. While some, me included, have applauded the ICC prosecution of al-Mahdi as a victory for the institution and its groundbreaking legal precedent, others have criticized the court's decision to go after a relatively little-known defendant for a relatively, and I emphasize relatively, what some consider to be an insignificant crime. One can't ignore, for instance, that al-Mahdi is the first ever defendant in the ICC to plead guilty. From the start of his case, he promised to cooperate with the ICC in exchange probably for a lenient sentence, although I think 9 years is quite a hefty sentence. Thus prosecuting al-Mahdi, while knowing in advance that he would plead guilty and cooperate with prosecutors, also perhaps provide information about future cases, was actually a really good use of the ICC's limited resources. But the reality is that it's very arguable that if he didn't plead guilty, these cultural crimes may have gone unprosecuted. That being said, the al-Mahdi conviction bolsters the ICC's image as a relevant institution prosecuting crimes. Its whole raison d'etre is to prosecute crimes that shock the conscience of mankind. And by having prosecuted these crimes against religious buildings, they confirm that these constitute crimes that shock the conscience of mankind. So it's also important to mention that all of the buildings that he was charged and convicted of were under UNESCO protection, and some had even been listed as World Heritage Sites. And because of its limited jurisdictional reach, the ICC has been, unable, I'll just skip. How does this help us move forward in the case of Artsakh? Although neither Armenia nor Azerbaijan are parties to the ICC statute, the provisions which form the basis of the charges against al-Mahdi derive from existing rules from the Geneva Conventions, as well as customary international humanitarian law, to which all states are bound. The only issue then is about enforcement. At the domestic level, the Geneva Conventions impose the obligation on states to investigate and prosecute war crimes amounting to grave breaches. At the regional level, it may be enforced through a body such as the European Court of Human Rights, which we heard more about this morning. And then there are various UN organs like the Security Council, the General Assembly, etc., ultimately until the International Court of Justice, or the ICC, which I've already discussed. To conclude, the most effective way to protect cultural heritage and prevent or punish cultural crimes in Artsakh, Armenia, or anywhere which doesn't fall under the ICC's jurisdiction will be through a fragmented and creative application of R2P, as well as diverse instruments of international law. Whether to what extent that application will take place will depend on the availability of resources and, of course, on political will. But as I hope I've managed to at least introduce in the limited time I've had here, where there's a will, there's always a way. Thank you for your attention.